Hi, everybody. Hello and welcome. A very good afternoon to you all. Welcome to the monthly knowledge webinar conducted by KelpHR in association with the Indian Lawyers Association. As you all know, we have a monthly knowledge webinar where we discuss certain topics which are of great relevance to PoSH law and also some associated subjects. Today, we have a wonderful panel of speakers, and I'm so excited to get down into the specifics of the topic that we have, because it is a very critical topic, and yet one where there is still some, lack of understanding and probably some difference of opinion as well. But before we do that, I'd just also like to say that we always conduct these sessions in association with the Indian Lawyers Association, which has chapters across India. So if you are a lawyer or a law student, you're invited to join and grow this community of lawyers. All right, so now let me tell you a little bit about the panelists we have today. Today's speakers are Dr. Sandya Advani and Sanam Kabre. Dr. Sandya is a versatile professional with over 33 years of experience in various domains. She retired as Director of Administration from Axelia Solutions Limited. She holds a bachelor's degree in Ayurveda and a master's degree in law. She's passionate about causes relating to women and has been conducting trainings on prevention of sexual harassment of women at the workplace since 2017. She is the founder of PoSH Systems. This is her second career post-retirement. That's really wonderful. Till date, she has trained over 34,200 people. She is a council member of the Maharashtra Anti-Sexual Harassment Council of Women's Indian Chamber of Commerce and Industry, also known as WICI. She serves as an external member of the internal committee responsible for handling complaints of sexual harassment for more than 30 companies. It is an honor and a great pleasure to have you join us, Dr. Sandya. Welcome.
Thank you so much.
We also have with us today Sanam Kabre. Sanam is an advocate at the Bombay High Court and Pune District Court and the founder of Sanam Kabre and Associates. It is a full-service law firm based in Pune, which has served over 200 clients in the last 7 years. The primary profile is litigation, and key areas of work include criminal laws, intellectual property, debt recovery, insolvency and bankruptcy, real estate, environmental laws, marriage, divorce and inheritance, and legal aid and social justice. Sanam has experience in mainstream as well as niche areas of law. Thank you so much for joining us, Sanam. Great to have you here.
Thank you so much.
And a little bit about myself as the moderator. I'm the content and creative lead at KelpHR. I am a trainer and a subject matter expert in PoSH. I deliver trainings in PoSH and diversity, equity, and inclusion. And just coming back to the topic for today, the very interesting topic that we have is the role of an external member, the goals and the challenges. So the external member, let's actually understand who is an external member in terms of the PoSH law. The external member is mentioned in Section 4, subclause 2C of the Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act. So let's understand how they refer to this external member, who they say has to be a part of the internal committee of every organization. So if I can just refresh your memory or tell you a little bit if you're not already aware, the internal committee has to be constituted in every organization that has 10 or more employees. And Section 4 of the PoSH Act, we will be referring to this law as the PoSH Act for ease of reference. Section 4 says that every internal committee has to have a presiding officer and some internal members, as well as an external member. So what are the qualifications of this external member? The PoSH Act, Section 4 says, one member from amongst non-governmental organizations or associations committed to the cause of women, or a person familiar with the issues relating to sexual harassment. Okay, and so now if we want to understand what does this phrase, a person familiar with the issues relating to sexual harassment, really means, we may look at the PoSH rules. The PoSH rule states that a person familiar with the issues relating to sexual harassment refers to such persons who have expertise in issues relating to sexual harassment and may include any of the following. Someone who has at least 5 years of experience as a social worker working towards women's empowerment and in particular addressing workplace sexual harassment. Or, I have to read that as an or, right? Okay, let's come to that actually. Familiarity with labor, service, civil, or criminal law. So let me start off then with this question about how do we understand who is really an external member? What is their role and why is it important? Also, why did the law think it is important to have an external member? Dr. Sandya, if we could start off with asking you this question.
Before that, Amoolya, I would like to add the word familiar and those, specifications that are mentioned, at least 5 years of experience and familiarity with labor, service, or civil or criminal law is applicable for a local committee. It is not applicable for an internal committee. Now, in the past, the role of the men and women in the past, the men went out to work, the women stayed at home, they looked after the cooking, they looked after the children, etc. Even when they took up jobs, they were women-centric jobs, right? So which was, stitching, teaching, nursing, those kind of things. Now, later on, when she stepped out, she went out to work post-industrialization, she started working. She used to get paid less. And it was advantageous for the employer to hire such a person. But because of this, the man started feeling threatened. He wanted to get rid of them. Now, what is the easiest way to get rid of them is to harass them. The women started facing sexual harassment. Now, the law at that point of time that was available was that she could go to the police and file a complaint. How many women will actually go to the police and file a complaint? Not really. She would rather quit the job or she will continue to suffer. Now, this is what kept on happening. And the government realized that there needs to be a forum which makes it easier for a woman to file a complaint. And this forum needs to be within the organization. And that is the reason why the PoSH Act was passed. And under the PoSH Act, there is a forum, which is the internal committee, which is created where a woman can go ahead and file a complaint. Having said that, the role of the external member is dual. One is towards PoSH compliance. Second is towards the complaint handling. As far as PoSH compliance is concerned, it is, the external member is expected to ensure that the policy is in place, the posters are displayed, there is correct documentation done for the formation of the IC, including board resolution, letters of nomination issued to the various IC members, ensure that there are quarterly IC meetings which happen, ensure that there are trainings which happen, at least once in a year, PoSH awareness for employees, IC training. And at the end of the year, you have an annual report which is filed. In case if there are queries which are received from the district officer, those queries also have to be answered. So this is as far as PoSH compliance is concerned. as far as complaint handling is concerned, the external member brings in an impartial perspective. The person also brings in knowledge, experience, expertise, experience. And because of the presence of the external member, it inspires confidence in the minds of the parties that yes, there is a possibility of justice. Justice will be done. The other IC members, do not will be prevented from being influenced by the senior management, if any, if required. So the presence of the external member will bring in that kind of respect, will bring in that kind of credibility that yes, justice will be done.
Very interesting. So thank you so much for, first of all, setting that historical context, right? I think it's really important for all of us to understand that this is not happening in a vacuum. And in fact, many times as trainers, we get the question, why do only women have this law? So there is a context to it. There is a story behind it. So thank you for sharing that with us. And yes, as to the role of an external member, I think you have put it very succinctly that it's dual. It's like, there is peacetime and there is wartime. You may have, your normal functioning, which is that you have to have your compliances in place. Would you like to also talk a little bit about QRMs, review meetings that an external member might have with IC member, with the internal committee, just to kind of give them regular updates?
So every quarter, and the IC is supposed to meet up whether there is a case or there is no case. IC is supposed to meet every quarter, and here is where the external member can also play an important role in knowledge sharing, sharing some judgments that have come in. So
Yes.
that's how the IC members are updated. Like many a times I have a quiz. So I have a quiz which all the IC members participate. So that's how the knowledge also gets refreshed. And, people enjoy the session. There is a learning there. So you can, use that opportunity for various initiatives. Maybe you want to plan out, now you've got Women's Day coming in. So you want to plan out something. So those kind of things could be discussed. Any other concerns which are there, those could be discussed. Apart from this, the external member also guides the IC members in case if, say, for example, there is a complaint which has come in or some kind of a, complaint that a woman has brought in and the IC is not sure what is to be done or they need some guidance. So the external member provides those kind of consultations also to the organization.
Absolutely. Thank you. Thank you again for talking to us about that. So just to again recapture what Dr. Sandya was saying, that, the compliances and these knowledge sharing sessions are also very important. The external member doesn't become, part of the committee only when there is a case going on. And I think that may actually be how some companies practice, having an external member on board. So great. Thanks for starting us off here. I think where you spoke about, the law foreseeing the need for an external member, I'd like to ask Sanam to come in here and tell us, what would you say are the eligibility criteria? I mean, apart from what we read, right? Are there any restrictions on who can be an external member? I understand that you're also an external member on committees. So there probably isn't a restriction on men being part of external members. So tell us about this.
Right. So firstly, we need to understand the constitution of the quorum of the internal complaints committee. And once that is satisfied, you have the external member. So as per the statute, the total quorum should have a capacity of 50% who are women. And there's an external member. And as per the statute, there is no bar on the gender of such external member. Any person can become an external member so long as certain other qualifications are met. For example, the person who is desired to be an external member should be either working with a non-government organization or an association which is specifically dedicated to the cause of women, or is familiar with issues revolving around sexual harassment and has had a few years of experience in, say, social justice or social work, especially towards the cause of women. That is what makes the person eligible to be a part of the external or rather makes this person eligible to be the external member of the committee. So
Right.
as no bar on gender.
Right. Okay. Great. Thank you for clarifying that. Can I also invite you to talk to us a little bit about what can happen if the external member is not the correct appointee? I mean, if the company has not followed some of the tenets or not vetted the qualifications of the external member, what can happen then?
Right. So at the outset, if the eligibility criteria as laid down under the Act with respect to the external member or even the internal committee is not met, that opens up exposure of the committee to be challenged by way of an appeal before the industrial tribunal.
Right.
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 Because mandatory compliance laid down under the statute is not followed. So at the outset, we have an exposure which is created wherein any ruling, no matter how good the merits are or how well it was decided by such committee, if the mandatory compliance laid down under the statute is not met, that creates exposure, and by virtue of that, the said ruling of the internal complaints committee or the finding or their mode of dispute resolution can be set aside by the industrial tribunal merely because the compliance was not done. So this compliance is not arbitrary. It is a part and parcel of the Act, and it is procedural and it is mandatory. Which is why while setting up the internal complaints committee and while getting the external member on board needs to be mindful of the quorum, the constitution of the committee, and the eligibility of such external member.
Very well put. Thank you so much for shining some light on that. So it is critical that from the time of formation of the committee, the company needs to keep in mind the eligibility of each person who is being appointed to the committee, and very much so the external member who is, as Dr. Sandya also put it, who can inspire the credibility, who can inspire the confidence of the employees in the committee's lack of bias and in the committee's expertise in handling such cases. Anything you wanted to add to that?
Amoolya, So just to add to that, a decision taken by an improperly formed IC is liable to be set aside. Okay, a very famous case in this is Ruchika Singh Chhabra versus Air France, wherein the external member who was appointed was a labor lawyer. And the court said that the term, they used that particular Rule 4. The court said that this Rule 4 relating to, experience in labor law, civil law, service law, criminal law is applicable to a local committee. It is not applicable to an IC. So as such, that decision was set aside. So bottom line is, if the IC is not properly constituted, a decision taken by an improperly formed IC is liable to be set aside.
Absolutely. So as you can see, it is like both Sanam and Dr. Sandya said, no matter how good the reasoning in your report might be, how much you may have worked on, conducting a proper inquiry or, ticked every other step in the proceedings, if the initial step of constituting the committee was not properly done, then the whole ruling is liable to be set aside, and which again, it's not just about that particular ruling that actually, destroys the trust in the company's governance structure, and it can have, greater fallouts. Okay, so we're off to a great start here in understanding what is the role and the importance of an external member in the internal committee. So now I would also want to know, I mean, you have had a lot of experience, Dr. Sandya, in sitting on these committees. I would like to understand broadly what have been some of the challenges you may have faced in executing your role, and then we can maybe ask a couple of specific follow-up questions.
Wow. So number one is the IC is comprised of people who are primarily lay persons. They may not have the legal background. Now, having said that, a lot of times, IC members may think, and that's where the role of the external member is important. Why are we spending so much time on this? Let's finish it quickly and, get on with our life. The required due diligence that is needed when you are conducting an inquiry is very, very important, because at the end of the day, whatever you decide is going to impact people's lives. So many a times I have seen ICs, they are not properly trained. Even the external member has not guided them correctly. One case I saw where the woman filed a complaint on 8th of April 2019. The same day, a copy of the complaint was given to the respondent. On the 9th, the respondent did her appraisal. Now, IC should not have allowed the person to do the appraisal. She lost out on a performance bonus of almost 3 lakhs. Response from the respondent was not shared. I mean, these kind of procedural lapses. So ICs need to be properly trained. They need to have clarity on how each step has to be decided and how each step progresses. So one is lack of knowledge, improper training, shortcuts. At times an organization may take people who are at a very senior level. I mean, I do understand, they want to bring in seniority and experience, but at the same time, that person should be able to devote time if and when a complaint comes in. If the person is not able to devote time, then, the person will not be able to pay proper attention when an inquiry is going on.
Indeed.
So you can't have shortcuts. You need proper understanding. You need proper due diligence. One more challenge, many a times, when say, for example, a complainant is making a statement. Now that statement is recorded. So of course, after taking permission, but then to transcribe that statement is a very painful task, because you're going to listen to the recording and then write it down. If you summarize it, a lot of times the nuances are lost. So this large organizations should have some kind of stenography support, that they can get the person to sign an NDA, that person is attending the inquiry and taking notes. And once the notes are taken, the person is able to type it out and give it. So then things will move faster. We will not spend so much time, because preparing the statements itself takes a lot of time. That's one of the biggest challenges I have. That's one of the biggest challenges. And many a times you have all senior people. Nobody wants to take that effort of documenting things. So it all comes on the external member. It all comes on the external member. Now, is the external member supposed to be taking notes, or is the external member supposed to be paying attention to ensure questioning and all is happening in the right way? So that's one of the biggest challenges. Transcription support. Proper training of the IC needs to be done. They need to be clear on what is to be done. MOMs need to be taken down. Every time you have an inquiry, you need to document the minutes of the meeting. This is exactly what happened. Later on, if you need to go back and check what exactly happened, you have all the records. Report writing, all of this. So all of them have to work together as a team. Even once you have come to a decision, you have to have a joint deliberation as to whether these incidents are proved or not proved. Some could be proved, some could not be proved. So there has to be a joint deliberation. You have to apply your mind when you're deciding on the punishment, which has to go as per doctrine of proportionality. All these things have to be kept in mind. So the challenge is mainly lack of training. Challenge is mainly lack of training. That's lack of training. Train them. Lack of time. Many a times they don't have time because the senior people are there.
Seniority.
There's this transcription support. That's a major one.
Yes, I'm so glad you bring that up, because it's not like the external member can be caught up in a lot of that admin, the task of transcribing. And like you said, their role is also to participate actively in the hearing, right? So if they're going to be, they can't really split their mind between taking, accurate and complete notes, as well as asking follow-up questions and paying attention to body language. Those are also very key aspects of the conducting the meeting. Absolutely.
When you take summary notes, you lose out on the nuances. Right? And those nuances become very important. Say you ask a question to a person, you're asking the respondent a question. The respondent is dilly-dallying, not answering, evading. If you have it verbatim, you can capture this. But if you just got the summary of it, you'll not be able to capture all that.
Very true.
In such cases, many a times in incidents of sexual harassment, there is not much evidence. The statements of the witnesses become paramount. As such, ensuring that you have the statements more or less verbatim really, really helps in deciding whether this person is guilty or not guilty.
Absolutely, absolutely. Right. And actually, now that you talk about the fact that, sometimes there's an expectation on the external member to do everything from A to Z. Yes, it is important that they check with the external member, what should we do next? I think it's important to keep them involved and make sure that they are vetting the process that is being followed. In your experience, have you seen sometimes an over-reliance on external member to do everything? Or have you also seen that sometimes they leave them out of the process and then, just call them in at the end when the report is being done?
No, so I do not work with a company where I am kept out. Either I am partnering or I'm not there. As simple as that. If
Right.
I'm with you from step one, guiding you through the entire process. Now, there could be times where maybe you can come in at a later point of time. That is only if the IC is extremely seasoned, well-trained. In such a scenario, they can look into the complaint, whether it is a complaint under PoSH, speak to the complainant, check if there is a possibility of conciliation, that is settlement, and then drop the settlement document. So only up to that much. But the moment you have an inquiry starting, you have to be a part of it from day one till that report is prepared and submitted.
Absolutely critical. And yes, I'm really glad to hear that you will not sign something where you are not involved in the process. Every external member has to have that integrity. There is so much at stake in a sexual harassment matter, not least the lives and careers of the parties involved. So absolutely, the integrity is really important. Sanam, would you like to weigh in with your experience on this?
Yes, most definitely. So to add to what ma'am said, firstly, the role of the external member should be well defined since the get-go. And like ma'am said, you are either a part of it since the beginning or you're not. You cannot come and go as you please, or at the same time, you cannot be invited at the behest of the internal committee whenever they want you, right? Because then your capacity of delivering results as an external member can be compromised. Now, that being said, I'd like to add emphasis to what ma'am said in the beginning with respect to recording the victim statement. Now, the role of the external member over here is essential because, firstly, the external member is an external member. That being said, the member is expected to be neutral, unbiased, and to bring a fresh pair of eyes to the proceedings, correct?
Yes.
Since the external member also carries a level of expertise which is far greater than the internal committee, little things like observing the demeanor of the victim giving the statement, and which is why what ma'am said, that recording the statement verbatim goes a long way in effectively deciding the dispute. Further, so basically, to ensure that these things, that these little nuances and details are paid heed to, it's essential that the external member is a part of the proceeding since the beginning. But at the same time, there should be mutual understanding between the internal committee and the external member that the job or the role which is being dispensed by the external member is restricted to just that, right? Right. Otherwise, what happens is, merely because of the expertise which is carried by the external member, it creates this element of over-reliance on the external member, right? And and that can also lead to the proceedings being compromised at some level, because ultimately even the external member is a human, and when that human angle gets involved, when you get over involved into something, you need to zoom out.
Indeed, yes. Very, excellent point you bring up, that it is a committee at the end of the day. It is not, all the other members cannot also wash their hands off the responsibility of paying due attention, taking necessary notes, and turning up for all the, internal meetings and everything, just by thinking, oh, there's an expert who we have and they will take care of everything.
Although
yes.
That the external member must attend all meetings of the internal committee, I think the external member by choice or as a matter of principle must be a part of critical meetings that happen with the internal complaints committee. And finally, to conclude, I feel that as much as a sensitization workshop for the workforce of the organization is important, I think the internal committee also deserves a separate training session of its own, because like ma'am said, the internal committee is more often than not consisting of lay people who don't quite know procedure and probably don't have experience. And it's not very often that you find an internal committee that's entirely seasoned to deal with a case the way it's supposed to be dealt with. So yeah, just to conclude.
I'd like to add something, Amoolya.
Yes.
See, the internal committee, as Sanam also said, is comprised of people who do not have a law background. Having said that, the external member needs to handhold the committee through the entire process. Which means, see, they would, unless you tell them or you teach them, how would they know? Right? So say, for example, if you're sending out a first notice to the complainant, what are the things that should be included in that? That needs to be guided. Every step, any kind of documentation, if you're forwarding a copy of the complaint, so what should be the template? What should be the format? All that guidance has to be given at every step. Once you've got a template and they've handled one complaint, then they know, okay, next time this is the process that we need to follow, and it becomes easier. But from the beginning, you need to handhold them till you are confident.
Yeah.
Yes, they are able to handle it. And ensure, because at the end of the day, the complaint needs to be handled properly. Whether this person did it or the other person did it, the job needs to be done.
It has to get done.
The job
I
needs to be
completely
done
agree.
and needs to be done in an effective and a fair and an impartial manner. Because at the end of the day, if the complaint is not properly handled, matters can go into appeal, which means the organization's name gets into public domain, and that's the last thing organizations want. The job needs to get done. If IC is trained, they're able to handle it, very good. If they are not, you've got to handhold them through the entire process.
I'm in complete agreement. Yes. I mean, how the IC has to participate, has to commit, but external member remains the expert, has to handhold the IC through the process.
Sure.
But yes, actually, now that you're mentioning appeal, right? Yes, sometimes, cases can take that turn. A party may be dissatisfied with the verdict of the IC. Let's understand what can happen then, and what can an external member do? Is there any liability that we're looking at for an external member?
Sure. So a party who is not satisfied with either the findings, they're not satisfied with the findings in the sense innocence or guilt, or the recommendation, the punishment that has been provided, or third, the employer has not implemented the recommendations. So in such situations, the party can go into appeal. Having said that, will the court admit all the appeals? The answer is no. The court will admit an appeal if principles of natural justice have not been followed. If the processes of law have not been followed, there's a violation of the processes and the laws. Third, if the findings are so perverse that no reasonable person could have come to those findings. 3 people have said, yes, we saw this happening, still IC says it's not proved, right? And the fourth is, if the punishment is shockingly disproportionate to the offense, in such a case, matters will get admitted. Now, once it gets admitted, if you have done your due diligence, you have followed the process, the various steps that need to be followed, ensured proper documentation, even the findings that you have come in and you have published in the reports are reasoned findings where there is a rationale and the basis on why you have come to the finding and why is it that you have decided this punishment. So when you have a report which is prepared in this manner, then you don't go wrong. You followed, your matters will not go into appeal at all. And many a times there may be a push from the organization that we should terminate this person's services. No. You do what is right, because tomorrow, if the matter is challenged, and you will go back and say, see, I told you this person's services should not be terminated. They say you should have guided us correctly. There have been times where organization is pushing for termination, but if the case is not that strong to warrant a termination, the IC has to hold back and give the punishment which is appropriate. Because at the end of the day, IC has the powers of a civil court. You have to do justice. If you don't do justice, it can go to court. You will be asked, why, how is it that you have decided and there is hardly any evidence? Then what are you going to answer? The management told me to do this. You can't do that. No, you can't say things like that. So you have to have
So
a
true.
balanced approach. You have to have a balanced approach and ensure that whatever is right is getting done without any pressures.
And sometimes this means, external member has to stand up against pressure from management as well. Yes. And it can be difficult. So, at least in writing, somehow they have to convey that, if the report is being published, I mean, if the report is saying something that the external member is not in complete agreement with, then it is best that they place it on the record, saying that we do not agree with this decision.
Yes, yes. And you give your reasoning. Say, for example, somebody
Yes.
is saying something, you give your reasoning. This is the reasoning. There is not enough of evidence. It matter can get challenged. It can go to court. Would you want the company name to get into public domain? Right? So
Yeah.
Organizations have taken you up. Why? Because they rely on your expertise and guidance. If you don't do that, what is the point in you being there?
So true. So true. Yeah, absolutely. So, as such, yes, it is the duty of the committee as a whole to ensure that a just verdict is delivered. But the expertise and the lack of, the absence of bias that the external member brings in has a huge impact on how this role is carried out, on how the IC's total responsibility is carried out. Okay, Sanam, is there anything you would like to add to this? Oh, I think we may have, he's on the call. Okay. No worries. Maybe when he joins back, we'll continue. But Sandya ma'am, actually, now that we have kind of come to an understanding of, the importance of this person's role, and how they can make sure that there isn't any adverse impact in terms of what the IC, the justice that the IC has to deliver. We know that many people want to be PoSH enablers. They want to, they want to be part of, they want to be part of this cause. They want to do something in this space. A lot of people, since I joined this space, reach out to me and ask me, how can I be a PoSH enabler? And I know there are some qualities and there are some qualifications. What would you say about this? Can you share?
That's a very sore point with me.
Oh, yeah.
So the thing is, people do a one-day training and they call themselves as consultants and enablers and all that stuff. Can you really understand the law in just one day? It's
I
ridiculous
took
to
5
think.
years and I still don't think I
Yes.
understand it completely.
I have a master's in law. I started studying this subject in 2017. Till date, I will say I do not know everything. Law is like an ocean. You have to keep reading. You have to keep learning. Very, very important. In one day, you're not going to learn anything much. You can do the course, okay, as long as you follow it up with regular reading, right? Now, there is a very famous phrase, law is a jealous mistress, right? Law is a jealous mistress. Why do you call her a mistress? Because she keeps you away from your family. And what does she want you to do? Wants you to be with her. That means you got to keep reading. You got to
Possessive.
Yes, absolutely. You got to keep reading. And so what could you, in case you want to build up your skills, what is it that you could do is ensure that you keep reading. Don't just stick to one book. I would have not less than 40 books on PoSH written by different people. So each person brings in a different perspective. So there is a lot of learning. So one is to ensure that you keep reading on a regular basis. Two, ensure that you subscribe to various law journals. So the new judgments that come out, you're aware of whatever is happening. Be a part of WhatsApp groups, which have got all the external members in there. So engage, participate. You may ask questions, people will answer. That's how there is a mutual learning. So these are a couple of things that you do: attend webinars, conferences, participate. All those things you have to, if you are serious about it and really want to make an impact, you have to eat, breathe, drink, sleep, dream PoSH. If you're ready for this kind of dedication, you will go places. If you are not, you're wasting your time.
Wow.
There is no shortcut. It's not a quick and easy money kind of a scenario.
No, definitely.
Have to put in that effort, because at the end of the day, people's lives are at stake. You can't be casual about it, or just, take it in, handle things in a very slipshod manner. No, you can't. You have to be serious about it. See, if you're not good, it's visible. You'll not last. You'll not last.
Absolutely.
As simple as that.
Yes, I completely agree. And I think these are the discipline required to, show up every day to your desk and do the reading. Whether you feel you have seen it's one act, but then there is so much history, there is so much legal context behind it. And there are other jurisdictions where there are, where there has been development in the laws in other directions. So there is always so much to learn, so much to question, so much to debate. And like you said, that WhatsApp group, I think, just being part of some groups where there are vibrant discussions going on. And it's okay to ask questions, right? It's okay to be curious. And even if in the beginning, you can shadow someone and learn about the process, where, you show up as an observer for some meetings and you just understand how it's done, so that you're better equipped to actually carry out the duties when you do become an external member. Yes, in fact, like you said, it'll show. If you don't know what you're saying or doing, it will show. You will not last. Absolutely. And I think in terms of qualities, like what you said now, I would say, would amount to qualifications in a sense. We have Sanam back with us. Okay, hi Sanam.
Hi.
We were just talking about, what should someone, especially if they don't have a law background, how can they come on board to be a good external member?
Right.
I was wondering, do you have anything you want to add to that?
Right. So, as the act itself suggests, that you don't necessarily have to be a lawyer or someone with a legal background. In fact, the first priority is given to somebody affiliated with a non-government organization or someone working in an association which is specifically dedicated to the cause of women, or has had in cases dealing in cases pertaining to women. Now, that being said, if you're not a law student or a legal person, so to say, you can always acquaint yourself with literature with respect to PoSH. You can frequently update yourself with Supreme Court judgments with respect to PoSH, access repositories, wherein commentaries about PoSH and the various trends with respect to PoSH are shared. And of course,
so make friends with law students who have access to these journals.
Definitely, I think it's the best way to go about it. Yeah.
Or subscribe to them yourself.
Yes, and learning is a never-ending process. So the more you learn, the more you grow, and then eventually you reach a point where you are equipped with enough information to dispense your duties properly.
Indeed.
To add to that, see, when you're reading a book, you will come across multiple judgments. I just quoted one judgment on Ruchika Singh Chhabra.
Yeah.
Go online, look for the judgment, read the whole case. Yeah. That is how you will start understanding how the judges think, how do they apply the law. So don't just look, okay, this was the case and this is what happened, but go back and read the judgment. You will understand the nuances and it will help to mold your own thinking, and which will be helpful when you're handling cases.
So that basic curiosity, like what does the primary source say? Not just what does a commentary say or the news report say, but what did the judge say? What were the facts? If you have that curiosity and, the discipline, then you can build up your abilities, whatever your background may be. I think you can build it up by showing up every day. Yeah. Great. Thank you so much. I'm sure that advice really helps a lot of people here who may have great intentions and are looking to convert that intention into action. The chat window is going quite crazy, so I'd love to take some questions. Panel members, please do share your responses to these questions as well. Dr. John Sarkar says, is it mandatory for external NGO member to attend every meeting, hearings, etc.? I think this question we did respond to.
was I mean, as per the Act, it is not mandatory for the external member to attend every meeting. But like I said, as a matter of principle, and also what ma'am said, that you are either in it since the beginning or you're not, right? So as a I think it's important for you to be a part of at least the monumental proceedings with respect to recording of statement, submission of evidence, examination of evidence, and all of that. But yeah, I mean, as per the statute, it's not mandatory for an external member to attend all meetings.
That's right. Yes. In terms of the statute, I think the quorum does not mention the external member. Rather, it mentions that the presiding officer has to be part of every hearing. Great. He also asks, what are the pay scale of external NGO member, whether it's monthly or annually? But I think that depends, right? It depends
That
from,
the professional you are bringing on board as an external member, and see, some of them actually do it pro bono, free of cost. Some of them, I mean, that also depends on the organization in question. Other than that, I think they have like an hourly rate, especially lawyers who board as external members have like an hourly rate, which is the per billable hour. But yeah, it entirely depends on the organization and the professional.
That's right. Yeah, it's a contractual understanding which you can have with this external member, and it depends what are the terms that you agree on.
Correct.
So, Amoolya, primarily what I do is I see what is the size of the organization. If it's a smaller size, charges are according to that. If it's a larger organization, charges would be according to that, because then they would have multiple offices also, multiple stations, and they would have many more complaints and things like that. So depends on the quantum of work that you would be required to do. Accordingly, you can quote some amount.
That makes a lot of sense. Yes.
So that's how you do it, depending on what all would you be required to do. If you are an external member, you are ensuring all the things are in place, attending quarterly meetings, doing the trainings, helping out in the filing of the annual report, answering questions, consultations, all that. You have a fixed amount per month. So you can bill it maybe per quarter, you could bill it per 6 months, choice is yours. So it would go as per the amount of work that is required, as well as the size of the organization. Like say if its organization has got 7 offices, annual reports will have to be sent for all the 7 offices. So obviously the workload is much more. So you'll have to look at that and then decide.
That makes a lot of sense.
Yeah.
Anuradha asks, how do organizations assess and onboard the most suitable external members? It's an interesting question. Are there specific criteria established for this purpose? We did discuss what the law says are, the criteria for this purpose. And it is basically a person who is from a non-governmental organization, someone familiar with issues related to sexual harassment, someone who is committed to the cause of women. But how do organizations assess and onboard? Yes, it's an interesting question. I throw it open to you, panel members.
So organizations would look at the background, educational qualifications, experience, expertise when they are taking on an external member, because the external member has to partner with the organization.
Yeah.
Right? Has to partner with them through the PoSH compliance journey. So handhold them through the entire journey. At times, you may have somebody calling you at 10 in the night also, this is what is happening, what do I do? You have to be able to, you have to answer those questions, even if it's late or something, if it's urgent, you have to be there. That's important.
Yeah. You have to, there are critical times, especially, it's a very sensitive matter, and there are sometimes when it involves people very high up in the organization and things have to, be done very confidentially, and, it's very critical. So I think a few conversations with the external members, understanding when you have an idea what their role will be, having conversations with them and understanding what they can do, what is the range of their experience and how best they can support you. If that inspires your confidence, perhaps that would be the right way to select the external member.
I'd like to give you an example. Very recently, I had a case where the presiding officer called me and said, we had sent out a mail to the email to the respondent saying, please come and collect the complaint copy from us. Right? So instead of sending it out directly like that, we said, please come and collect the complaint copy. Now, once this mail was sent out, he sent a message to the complainant, I am going to commit suicide. Okay. he also sent a message in the managers group that I am going to commit suicide. Now, obviously the organization, the lady got, the presiding officer called me and asked, what do we do in such a scenario? So somewhere that legal background helps. You can't say, okay, no, don't do anything. Nothing is required. He's not going to do it. What if he actually goes ahead and does it? Who is answerable? Who is responsible? So somewhere that knowledge of law helps. Even if you do not have that, it's always better to keep reading and keep on equipping yourself with the necessary knowledge.
Yes, so true that we have also come across some situations like this, very delicate and very scary also as well. And that, the background, the experience definitely matters. Nitin, we'll just come to you. Just give us 2 minutes. We've got some questions on the chat as well. Thank you so much. I think some people are agreeing that transcription is a challenge. Documentation is a lot of pain. It's been a decade since the Act is in place. What is the success percentage of IC or Dr. John Sarkar? This is, I think, another session. This is a topic for a whole other session. We can't start discussing that now. But there has been a very interesting study by the Martha Farrell Foundation. I could, just suggest you could go look that up as to the extent of implementation of the PoSH Act. There are some surveys and studies that come out that talk about this. We could have another session about this though, for sure. Rupa Reddy says, like transcription, can we also involve other experts during any case discussion if needed? Right. Okay. So
Yes,
experts like a doctor, a psychologist.
You can. The IC has the powers of a civil court. Having said that, IC can summon any other person also as a witness. If IC requires some technical guidance and expertise, IC has full authority to summon that person and get that person to testify before them. So there is no bar as such. You can do it and the organization will pay the charges for that.
Absolutely. So yes, there may be some need for an expert to testify, and the point is to get that material on the record. So you need to have it as part of the process.
Yes.
I hope that answers your question, Rupa. Sanam, you can jump in whenever you feel like. I mean, this is for both of you.
I see one comment in the chat box with respect to remuneration given to the external members. I just want to clarify. So 1 second, I'm trying to find the comment in the chat box. Somebody said, doesn't the Act say that it is 2,000 rupees as remuneration given to the external member? It is not 2,000 rupees. It is rupees 200 per day plus travel cost, but that is only the cost of proceeding, right? That every subsequent proceeding that the external member attends, he is entitled to receive an allowance of rupees 200 per day, correct? But the role of the external member doesn't quite end at proceeding level or, just end with that case. The external member also advises otherwise, right? So more often than not, external members have a contract with the said organization wherein he or she, they don't necessarily wait for a certain case to show up, and they are generally advising on procedure and other ancillary topics as well. So as per the Act, rupees 200 per day only for cost of proceeding and travel allowance. Right. So that is something that I wanted to get out of the way.
No, and it takes a lot of work and study and experience to be a good external member. It is not viable to only arrive at a sum of 200. I think there is some question as to whether it is capped at 200 or it is a minimum of 200.
It is not, because even the Act is ambiguous. The wordings of the Act, I think, to the effect that the external member is entitled to receive an allowance of rupees 200. There is no shall or there is no may provision of the law. You know what I'm saying?
Does it say only? I mean,
No. I don't believe it does. I don't believe it does. No. So, but it specifies that the rupees 200 allowance is for the proceeding cost.
Right. Thank you for shining some light on that. I hope that answers your question, Gaurav. I think. Wow, there is just a lot of So Savita asks, what is your opinion on the impending amendments or changes in the PoSH Act? In fact, we are going to have a session about that next month. Please join us where we discuss the proposed amendments in to the PoSH Act. It's going to be a very interesting discussion. We hope you'll all be here and you'll add to the conversation as well. Yeah.
The proposed,
Harish,
it is not yet
proposed amendments.
No, it's
Absolutely. Proposed.
What is the time it will take to become an amendment is a question mark.
And that too in an election year. Let's not hold our breaths.
Yeah.
Harish says it is not optional to have training sessions for IC. Absolutely, it is mandatory. I hope no one has that misconception that it is an optional thing. It is absolutely mandatory.
Having said that, I've had somebody saying, can you do a 1 hour training for the IC?
Oh God. Where do you start? I mean,
so I tell them that, have you seen judges? What is the amount of education that they go through? They finish graduation, then they do law. They do a master's in law. They are practicing for at least 10 years before they can think about getting on to the judiciary. They have to appear for an exam and then. Now, that is the kind of experience and expertise that you require. Do you think you'll learn that in 1 hour?
The law says powers of a civil court. I mean, imagine just becoming an IC member and so you're a judge in 1 hour. That's just crazy. It's like a whole new definition of fast tracking.
Yeah, so one has to explain. I generally do a full day session for the IC with mock complaint handling, etc. So those will give hands-on experience. By the time they've reached the end of the day, their thinking is molded to think like judges. And then one gives them case scenarios. This is what is the finding. What is the punishment you will decide? So then invariably by the end of the day, they are now more balanced.
Yeah, molding the way of thinking.
Yeah,
yes.
and they're more balanced and able to answer correctly.
Then another question, Dr. Sarkar has a lot of questions today. Are there any government certification institutions that have courses and certificates to external NGO members, IC members? There are, in fact, some institutions have been empaneled by the Ministry of Women and Child Development. And I think through a Google search, you can find some of these institutions.
Amoolya, there is no government. There is no government certified course as such.
There is
organizations which are empaneled as trainers. Like if you're asking for a government certified course, not really. There was something in between which was there from the Maharashtra State Commission for Women. There was some course that they were running. That's all. But otherwise, there's nothing really standard.
Yeah, that's true. There is no certification as such. You're right about that. Yes.
Yeah.
Amoolya, there's an interesting question by Akshita. She says, as an external member, how do we navigate if there is bias amongst the IC members with respect to the respondent, just because we have been in the organization for quite a lot of time?
Okay.
I'll try answering that and then maybe ma'am can add to it. So in the event where the external member feels that there is some level of bias amongst the IC members themselves with respect to a certain respondent or even the complainant for that matter, firstly, the external member must express his or her concerns to the chairperson of the IC. If that fails, then he should escalate it to the primary employer or the higher management. And finally, when that fails, then you can probably involve the authorities like the Regional Labour Commissioner. I think that is the channel, in my opinion. I think ma'am can add to that.
Okay. So what we generally do is when the notice is sent out to the complainant, the first notice that goes out to the complainant has the details, please come and meet us with respect to this complaint that you have filed, date, time, place. You will put down, it is a disciplinary inquiry. The proceedings will be recorded. You are entitled to produce additional evidence. These are the people who will conduct the inquiry. If you have an objection to the presence of any of them on grounds of partiality or bias, please let us know by so-and-so date. Objections will be considered only if found valid. So this is the clause that is included in the first document notice that goes to the complainant. similar clause is included when the notice is sent to the respondent. So what happens is both the parties are aware who will be the people who will conduct the inquiry. In case if there is a likelihood of bias, maybe a person is in the same team as the IC member, then the respondent can say that, yes, I do not want her there because this person is a team member of this lady. So that person has to recuse. So you take care of this bias business in the very beginning before you start the inquiry proceedings at all. Otherwise, halfway through the inquiry, somebody will wake up and say, hey, there's a bias. No, you take care of it in the very beginning itself. So when you're starting off the inquiry, you check whether has anyone said anything about bias. If you feel, yes, this is valid, it is justified, ask that person to recuse and get somebody else to be a part of the IC for that inquiry.
Your point is noted, ma'am, but I think in some instances, you may realize the bias only after you may be new to the complainant may be new to the organization and may not have realized that there is a close relationship between the respondent and the IC member, in which case, perhaps we may have to look at how does the external member then kind of raise an alarm about the bias.
Yeah, sure. You can always hear the person out. And if you feel, yes, it is justifiable, then maybe you could make a change. But generally what happens is we mention it in the very beginning itself. Now, say, for example, if the person is a team member, the complainant would know that this person is a team member, or the respondent would know that this person is a team member.
True.
So, and apart from the complainant not knowing, what about the other IC members? Other IC members would know that, there is a relationship, there could be a conflict of interest. In such a case, then other IC member can say.
So each IC member has a responsibility to call it out if they feel that there may be a bias between another IC member and either party of the case. Absolutely.
Definitely, because at the end of the day, justice needs to be done.
Every IC member has a commitment towards justice more than to each other or to the parties. Yes.
Yeah, just to add into my question, Akshata. Sure. So in our situation, what happened was that the complainant had joined just 2 years before, and the chairperson of our committee ended up telling it to us that the respondent and she herself had joined together in year 2008, before any of us was there in picture. And she had like a lot of confidence in saying that I am sure that this person has not done it. And we all were dumbstruck totally.
That's a clear bias.
That is a clear bias. That's a clear bias. And I said, you're not even looking into the merits of the case. You're just simply saying just because you guys, both of you guys have joined in the same year.
That's the presiding officer, that too.
That's the presiding officer, and that too of a very nice, like, reputed organization. And she herself is a scientist. And I was like, this can happen and this can be slapped onto the face of the external member. And I was the only one in the room asserting that, please, let's go forward with the proceedings. Let's just not drop it here, because, and that was being recorded. The audacity was this much there.
So if there is
that is
bias, if there is a
kudos
clear
to you
bias,
for standing up to
why did you allow her
that.
to continue? Why did you allow her to continue if there's a clear bias? You should not have allowed her to continue. I had a case.
It would have been best to recuse, for that person to recuse
exactly.
themselves.
Because otherwise your entire decision can be set aside.
Yes.
Now, I had a case where the presiding officer was the direct reportee of the respondent. We had to raise it up that she cannot be the presiding officer. She can't be a part of the inquiry. Don't you think she's going to try and favor her supervisor? She'll definitely do it. So do not allow that. Otherwise, your report will be set aside.
Yes,
totally.
That's always the
I
risk,
told them that was the only deterrence which I had in my hand, to tell that, that can be challenged and you guys cannot come back to me. I'm putting it on record that your chairperson has clearly said it on record. So that was from my end. Thank you
for sharing
so much.
I think let's just come to Nitin, that he has been waiting for some time with a question. Can we hear from you?
Ram ji. I have two queries, Dr. Sandya ji. First query is, before the query, I would like to tell the Sanam that in the act, it has written, shall has written with the 200 rupees. So kindly check. And Dr. Sandya ji, I would like to ask that as you said, and as I've read that IC get the powers of the civil judge, and that's only for the summoning. Yeah, that's only for the summoning.
Yes, summon and production of documents.
Correct.
Yeah. And now my query is, if I'm summoning to someone and he's not coming, can I direct to police to get that person to me or before our IC?
So to tell you frankly, Nitin, the act is very gray about this whole thing. There is no specific provision. Like for example, a civil court, a judge can ask the police's help to get, maybe issue a warrant, also ensure that this person is brought before the court. Whether the IC can do that is a question mark. There is no clarity on this. So what
in my understanding, we can.
May I add to that?
Yeah, sure. Yeah, go
Okay.
ahead.
So like you said, so powers of the civil court with respect to summoning a certain individual and production of documents, correct? Now, typically, before the police gets involved, now first of all, involvement of the police in a civil case, okay, understand the difference between a civil and a criminal court primarily, that before involving the police in a civil case, if a certain individual, especially the defendant or the respondent, is not present, the civil court has the powers to proceed ex parte against him. Now, what do you mean ex parte? It means the court will draw an adverse inference against such an individual that despite being given a reasonable opportunity of being present before the committee, or in this case, quote unquote, the civil court, right? This individual has clearly ignored or has not paid heed to the summons sent by the Internal Complaints Committee. And by virtue of the powers of a civil court given to the IC with respect to summoning an individual, the IC will also have the powers by that logic to decide a certain matter ex parte against such an individual. So here the question of involving the police doesn't necessarily arise because it is firstly a civil case.
They will declare him as an ex parte and will give our award.
Absolutely correct. But for that, the internal committee needs to show beyond reasonable doubt that reasonable attempts of service of summons have been made and the summons have been delivered to him or have been willfully denied by such an individual.
Okay. So in the rules, it specifies that 3 notices, where the third notice at least gives them time of 15 days to respond.
That I understand.
So this is fine. The question what I was answering, Nitin, this is there in the Act. If the person doesn't show up for 3 times, then IC can either terminate the complaint or pass an ex parte order. The question is, what if you are wanting to call a witness to you and the witness is not showing up?
Yeah.
What will you do in that scenario? That was the question that I was asking.
That is great.
That is
so
what
we can take the help of police.
No,
the police will not get.
There's no clarity on that. The Act is silent on that.
So we may.
What one generally does, Nitin, what one generally does is you will ask the person, maybe it's an employee's wife who was present when an incident happened. You can tell the employee to bring his wife. Now, obviously, if the IC is saying and he's employed in that organization, he will then bring his, wife across for, testifying. But any other person, outsider, if you ask the person, it's an ex-employee, the person doesn't show up. Can you really force? You can't really force. You'll have to look at other evidence and go on.
Okay. And another question is that that PoSH is applicable on every organization, including NGOs.
Yes.
Now, Act also says if you are having 10 or more employees, then you need to fulfill the PoSH compliances. Otherwise, PoSH is applicable on everyone, right?
PoSH is applicable on all organizations. If you have 10 or more, you need to have a committee in place. But
that's saying PoSH compliance.
But otherwise, you should be having a PoSH policy, do trainings for the organizations. So if you have even less than 10 employees.
Now my question is,
aren't your employees interacting with clients?
Customers? Yeah. Now my question is, there is an NGO and NGO is having a 7-member in the executive body and 50 other members, enrolled members, but there are only 2 employees. So do I need to incorporate a PoSH policy and do I need to constitute a committee, incorporate a PoSH policy and need to file the return or no?
So you need to have a policy in place. Now have a look at the definition of the word employee under the PoSH Act.
Yeah.
What does it include? It includes employees on rolls. It includes employees on contract. It includes
But
consultants.
there is a word that says working on a voluntary basis or otherwise. So every member is on the voluntary basis. I think so it's include.
So you should be having a policy in place. You should be doing the training. And these other 50 people, are they on a contract or how are they?
When they are the voluntary members of that NGO, let's say there is a RWA.
Yeah.
They are the member of that RWA.
I would suggest to go ahead and have a IC also in place. This is what is a best practice. I would suggest one should go ahead and have it.
Because I'm in that side, it's mandatory, but some other consultants saying it's not mandatory. But in my views, it's mandatory just because of single word on the voluntary basis. It's here written in the definition of employee, section 2E, 2F.
Correct. It's
Thank you
always
so much.
advisable to have it.
Thank you so much. And Sanam, you please check that shall has already been written in that.
Right. Thank you so much.
Take care. Thank you, Sandhya ji. Thank you, Amoolya.
Thank you, and I'm conscious of the time. It is 5:10. So I don't want to keep our speakers for too long. We have an amazing number of questions which we want to attend to. We'll do this. We'll take the questions and we can maybe share it with our speakers as well if they have any insights on that, and we'll also try to answer the same. And since you've registered with us, dear audience members, we'll share the copies of the answers with you. So I think this is just to say that we'll have to close today's webinar. Any parting words from you, Dr. Sandhya, Sanam? Can we hear from you?
You have to be dedicated and sincere. If you want to be an external member, work hard, have a focus. What is your goal and work according to that.
Awesome.
Right.
Thank you.
I'll only like to say that being an external member in itself is a thankless job. And no, I mean, it is what it is. You call a spade a spade. And as the law suggests, the legislative intent behind appointing an external member is very, very clear. So when they say that you have to be dedicated to the cause of women, you actually have to be dedicated to the cause of women. And which is why it's a thankless job. You cannot have any expectations in return. It is essentially to make a difference, right? And that being said, if you have that notion in mind, I think you'll do a great job. So other than that, I think this was a great session and a really underrated topic,
Yes.
which didn't have a lot of clarity. I mean, merely in 1 hour, so many questions came up and we all got to learn something new today. So this is great and I'm grateful that I was a part of it. And
yes, absolutely. Very grateful to both of you for your wonderful insights, for your keen participation, and to all the audience members. Thank you for being so vibrant, so engaged in this conversation. We keep having these conversations on a monthly basis. Do join us again. We'll be announcing the topic for the next, I think we spoke about that also earlier. And we'll try to get the answers out to you after we after we collate them and we share them with the speakers as well. Again, thank you everyone so much. See you also.
Thank you, Amoolya, and thank you to the audience. Lots of wonderful questions.
Can you raise an important point?
Yeah, go ahead.
Yeah. One important point I have is one of the panel members said to involve the labor commissioner in the event of a doubt. But I definitely see the intent of the law is very clear, not involve the labor department in any way, because it's IC and next is High Court and next is the Supreme Court. The process of the action involving labor department.
IC, then the industrial tribunal, then by way of an appeal in the High Court, and then the Supreme Court.
Some state governments have notified that the industrial tribunal is the authority.
But nowhere the labor department or labor been mentioned, because it does destroy the neutrality of the PoSH.
Correct.
Okay.
That's one. I have one more just important question. In case of a centralized IC team and having branches with the other states, can we have the annual return centralized, wherein it has got the data collation of all, And we also send the same return to the respective state also to submit them to their district office.
I
So
don't think
you
there
need
is
to
a
submit
provision.
it. You need to submit the annual report for every unit, administrative unit. You need to submit it. You could have a central IC. Many a times, I have clients who have got zonal ICs, North Zone, South Zone, East Zone, West Zone. Presiding officer, separate representation from various states. You have it in that particular manner. But as far as filing the annual report is concerned, you need to file it for every office where you have 10 employees or more. It needs to go to the local district officer.
No,
Sundar, go ahead. You're asking a question. You're saying something.
let me say I have one in Bangalore, I have one in Hyderabad.
Yeah.
And one in Chennai. My data is collected from all of them.
Correct.
And I send this to all the respective district officers, respective state. Now, should I have Tamil Nadu, only Tamil Nadu, Andhra, only Andhra, and Bangalore, only Bangalore, when I file the annual report?
What I generally advise is for each location, you send out separately for each location. If what you're trying to do is for Chennai, you're including data from Bangalore and Hyderabad. I mean, I don't think it is really required. What you need to send to the Chennai person is data for Chennai. If it's included, they may take it, not really say anything, but ideally you should be sending for each location, it goes separately. What you're doing is replicating the same thing across 3 locations. So it should not really be a problem, but ideally if you do it for each location separately, that's always better.
That is how we advise as well, Sundar.
Yeah. Thank you.
All right. I think we should let we have taken our speakers' time only till 5 p.m. and they've graciously stayed back. But we'll close today's call, and this will also be available on our YouTube page as well as on LinkedIn. You can always catch the recording of this session if you want to go back and listen to some of the discussions that we had today. Great. So I think we'll say goodbye. Thank you, everyone, again.
Thank you so much. Thank you so much.
Thank you.